Hello, everyone, and welcome to our webinar today about avoiding discrimination and harassment claims at work. So it's tips for employers and HR. Do also take advantage of the QR code on your screen right now to hire and inspire in the UK. It's a pretty good guide to have a look at. My name is Jay. I'm one of the senior legal consultants here at LegalVision, and my co-host is Saeidul in the employment and health and safety team here at LegalVision. He's a senior associate. He'll be in very good hands today. So just before we jump in, a couple of housekeeping items. This webinar does get recorded and you will get the slides in your email afterwards, and they're also available on our YouTube channel, so you can look at our previous ones and our future ones. And please do submit all your questions, as we will be having a Q&A at the very end. And we also do have a little feedback survey that takes about 30 seconds. If you could kindly fill that out for us at the end also, please. Cool. So by viewing this webinar, you all qualify for a complimentary consultation with us here at LegalVisions to help to discuss basically your legal needs and see if there's ways that we can support you. So just to claim your consultation, leave your contact details at the very end in the survey, or you can contact us through our website as well. So I'll hand over to Saeidul to run through the agenda and get into the juicy part of the webinar.
Yes, thank you very much, Jay. So today then what we're going to be discussing is understanding what really counts as discrimination and harassment in the workplace. We'll also look at third-party discrimination. We'll look at preventing discrimination, including tackling unconscious bias. We will look at handling employee complaints effectively. And then finally, we'll also be looking at avoiding financial and reputational damage from non-compliance. So what I'll do first then is I'll speak about what counts as discrimination and harassment in the workplace. So by law, employers really ought to protect the employees that they have from discrimination at work, and that also includes workplace events, which are seen as an extension of the workplace. And the main sort of piece of legislation that governs discrimination in the workplace is the Equality Act 2010. Now, discrimination in simple terms really means that someone is treated differently because of a protected characteristic that they have. And there are plenty of protected characteristics. In fact, there are 9, and that includes sort of disabilities. It includes someone's race, sexual orientation. It could also include things like their age, religion, or even their philosophical belief as well. When it comes to discrimination, it can come in many forms, and employees may suffer discrimination from really anyone they come into contact with because of their employment. And that does include discrimination by their own colleagues as well, and even third parties, which I will go into later on. Now, some forms of discrimination include direct discrimination, and this is essentially when someone is put at a disadvantage or treated less favorably due to one of those protected characteristics I mentioned, and that's in comparison to someone who doesn't actually have that protected characteristic, or it could be someone that is considered what we call a hypothetical comparator as well. Now, the exception here really is for pregnancy and maternity-based discrimination, where the discrimination simply means that the affected individual, so the pregnant person, is treated unfavorably without the need for a comparator, perhaps for obvious reasons. When it comes to other forms of discrimination, we look at indirect discrimination as well. And this is essentially where there is some sort of policy or provision, criterion, or practice, which applies to everyone, but it actually puts those with a certain protected characteristic at a particular disadvantage. Another form of discrimination is harassment, and this comes in a lot of different forms, as you can perhaps imagine, but primarily it relates to unwanted behavior relating to a protected characteristic which violates that person's dignity, or really it creates an intimidating, hostile, degrading, humiliating, or offensive environment for that person. And finally, victimization is when someone really suffers a detriment because they have done what is considered to be a protected act. For example, that could be blowing the whistle on some cyber wrongdoing, or they intend to do a protected act, or it's perceived that they have done a protected act. Now, these are just some of the forms of discrimination, and there are plenty of others as well, which I'm not going to go in through too much detail, but that could include things like perception-based discrimination, or even just a failure to make reasonable adjustments as well for a disabled employee. Now, some examples of the discrimination I mentioned beforehand, then starting with sort of direct discrimination. So that could be really when you prevent someone from being promoted, perhaps because of their religion or belief, which you believe conflicts with your own, or that's the company's own philosophy. It could be indirect discrimination, where I mentioned there is some sort of staff policy that applies to everyone, but maybe that policy actually makes it harder for someone with a disability to actually do their job. Or when it comes to harassment, it could be that there are perhaps employees in the workplace that make inappropriate jokes about someone's sexuality, which of course is a protected characteristic. And when it comes to victimization, it could be as simple as someone being denied a pay rise because they've blown the whistle, or we think they may have blown the whistle about some sort of issue in the workplace, for example, health and safety issues. Now, importantly, even if there was no intention to discriminate against that individual, discrimination can arise based on the treatment received by the affected individual and because of their perception of this as well. So intention isn't also important. It's perhaps rather more important we look at how the individual felt based on the treatment they believe they received. Now, coming on to third-party harassment, historically, in some circumstances, employers were responsible for any sort of harassment that their employees suffered at the hands of a third party. So that could be, for example, a customer in a shop, or it could be a client that you work with. It could be anyone really that you come into contact with. But this was actually changed back in 2013. So that is the case at the moment. But the current position is actually that an employee can potentially argue that their employee's inaction in cases of any sort of third party harassment actually amounts to some sort of unlawful act. But the key here is actually establishing liability under the current law is actually quite difficult because what the employee really needs to do is prove that their protected characteristic was actually the reason that their employer failed to protect them. So it's not quite enough to show that the employer failed to take action about the harassment, that perhaps discriminatory in nature, but the focus is really on why the employer acted or failed to act as they did, but not on the discriminatory nature of the third party's conduct. So perhaps it's easy if I give you an example of that. So let's say you've got a customer that sexually harasses a restaurant worker, and the manager responds quite sympathetically to that employee, but maybe inadequately. The employer isn't actually going to be liable if they were responded the same way, regardless of the employee's sex, i.e., regardless of whether the employee that suffered the harassment was a male or a female. But by contrast, if you had perhaps, say, a different situation with a shop owner, maybe with an ethnic minority worker who's experiencing some sort of racial abuse, and then maybe instead of acting sympathetically, the manager said to the employee, you have to expect a little bit of that because of your race, then actually the employer may be liable for harassment in that case because their inaction actually appears to be motivated by the employee's race. So you can see the distinguishing factor there between the two cases, because in this case, it seems like they're motivated because of the employee's protected characteristic rather than the third party's treatment of them. So, as you can imagine, this is actually quite a high threshold for employees to prove. And often, when an employee actually faces third party harassment, they consider different claims instead of sort of the ordinary discrimination claims that I went through earlier. And that could be, health and safety breaches, for example, and maybe even in some cases, constructive dismissal. But the starting point typically for an employee in this case would be a grievance in the workplace. Now, one fundamental thing to think about is the Employment Rights Bill, which has been introduced by the Labour government. And what it will seek to do as part of that bill is reintroduce employer liability for third party harassment. And that'll be from around October 2026, so around this sort of time next year. And that'll be reintroduced, or that's being proposed to be introduced, where both the third party harasses the employee in the course of their duties and the employer fails to take all reasonable steps to prevent the third party from doing so as well. Now, this is quite a significant shift back towards the stronger protection for employees, and it would actually place a proactive duty on employers to prevent third-party harassment rather than requiring proof that the employer's inaction was discriminatory in itself. For example, with the example I gave beforehand. But it really remains to be seen whether this proposal will be watered down before it actually becomes law, because it is just going through the motions through Parliament and the House of Lords, etc. at the moment as well. So we'll see, things do change as they did slightly change with the sexual harassment law that became law last year as well. Now, preventing discrimination, including sort of tackling unconscious bias, generally speaking, it is best to try and prevent discrimination in the workplace from occurring or even arising in the first place, because prevention is always going to be better than the cure. And this can be done in quite a few different ways. So it could be done with training, for example. So typically, when you have any sort of new starter, what you would generally tend to do is have some form of general diversity and inclusion training, and that could also be done when there is some sort of incident in the workplace, or if there is any change to the law as well. It's always a good idea to look at training. Staff policies is another good example of that. So that could include anti-discrimination or harassment policies, making it clear that the company has zero tolerance to any sort of discriminatory behavior within the workplace, regardless of how that comes about, whether it's direct, indirect, or otherwise. It's a good idea to think about having a grievance policy as well, where employees who are disgruntled know exactly how they can raise the issue formally, perhaps if they feel as though informally would not be sufficient, or because of perhaps the seriousness of the allegations themselves. So having that in place demonstrates to the employee you are willing to take it seriously in terms of any allegations, whether that's discrimination or otherwise, and it sets about the process that needs to be followed by both the employee but equally the employer as well in tackling that. A whistleblowing policy is also important, where the employees can take comfort knowing that you will sort of take action and the way you will take action in cases where they sort of blow the whistle on any sort of relevant wrongdoing, whether that's a health and safety breach or whether that's some sort of criminal offence or otherwise. It's a good idea to have that policy in place so they know exactly how to blow the whistle, who they do it to, and what steps the employer will typically take as well. And finally, when it comes to policy, I would always recommend thinking about any sort of equality policy as well. So that's just about touching on the different types of protected characteristics and the fact that you are an equal opportunities employer as well, meaning that you're not going to treat anyone discriminatory in a discriminatory way, perhaps rather. If they have any sort of protected characteristics, e.g., if you have some sort of internal promotion, you're going to treat everyone the same regardless of their status. Tackling any allegations of discrimination swiftly is also important as well, because if you delay taking actions, then employees may feel as though you're not actually taking the issue seriously. So if you ever do receive any allegations of discrimination, it is important to do that it is important to deal with that very quickly and efficiently as well. And that could be through the whistleblowing process or the grievance process, depending on the way in which that allegation has been brought about to the company's attention. Promoting inclusivity is also important. So that could be ranging from, general sort of workplace activities, maybe even outside of the workplace as well. So making sure everyone can benefit from that as well, because what we don't want to do is marginalize other groups or be seen to marginalize other groups as well, because that could be directly discriminatory or it could even be indirectly discriminatory as well. So promoting that is quite important, given that we have a diverse society as well. Tackling unconscious bias is also important. I'll talk about this more a little bit later on as well, but it could range from things like microaggressions, for instance. And also, in some cases, it's worth noting that employers can actually address workplace inequality without breaching the Equality Act 2010 through various means. And one way to do that is actually through positive action. So positive action is essentially where an employer does something with the aim of really trying to help with someone who is maybe disadvantaged because of a protected characteristic that they have, which could be because of their disability, or it could be because of their race, or it could be because of some other protected characteristic. So during recruitment, what that could mean is that an employer may perhaps encourage applications from an underrepresented group within their organization to try and promote or increase diversity in the workplace. This doesn't mean that you have to guarantee employment for example, an ethnic minority or someone who's a disabled employee, because ultimately you always need to make decisions based on objective criteria, such as the skills, the qualifications, work experience, so on and so forth. But what it essentially means that you might try and encourage applications from them just to try and increase diversity, but it doesn't mean a guarantee of employment. Now, for those that are already employed by the company, and when I say for those that are already employed, I mean those that do have a protected characteristic. Positive action could be where you take some sort of proportionate step to help that disadvantaged person or the group of disadvantaged people to sort of overcome any barriers that they may face within the workplace. So, an example of this could be you reviewing any sort of disciplinary and grievance policy. So, by law, for example, employees are entitled to be accompanied to a formal meeting by fellow colleagues or a trade union representative. But what you might do to make an accommodation for those with disabilities is that you might say to them, "Well, actually, you could be accompanied by your carer if you have one, or you might want to be accompanied by a friend or family for perhaps that emotional support that they can give that perhaps a fellow employee or a trade union representative can't give." So that could be seen as also a reasonable adjustment as well. Unconscious bias is an interesting topic, which is becoming more and more talked about, I would say, in society these days. And ultimately, it just means that when we perhaps unknowingly make a decision or pass a judgment on someone based on assumptions that we have or just false beliefs as well. So it's not something that's easy to tackle, I would say, because ultimately the individual beliefs and views held by someone are often shaped by their own life experience and actually sort of getting around that or getting someone to overcome that can be quite difficult because it may be that they've been set in their ways from many, many years of their life, particularly perhaps for the older generation. Now, in the workplace, unconscious bias itself can sort of lead to issues such as microaggressions, which I mentioned beforehand. So these are things that seem to be subtle, perhaps unintentional comment or behavior that can actually demean or exclude people or a person. So that could be, for example, let's say you had an ethnic minority who said, "Oh, I'm from somewhere in the UK," and you then said, "Well, where are you really from?" Then that could be seen actually as an inference that you're suggesting that the individual can't be from the UK because they're an ethnic minority. So it could be seen as actually a microaggression because it might unintentionally demean them in some way. Another example would be pay disparities between people doing the same or similar work. So a good example of this could be actually through male and female sort of, let's say people working in the warehouse as warehouse operatives who do the exact same job, but they receive different pay for that. So that could be seen as another form of unconscious bias as well, where we might think that wrongly that oh the men must be working harder, which is why they're getting paid more for it, which often isn't the case. So that, as I say, is a good example because in fact a lot of large organisations, in fact supermarkets, are going through the employment tribunal for these very reasons for equal pay claims. So that is a form of unconscious bias. Another one could be discriminatory recruitment. So that could be where we make assumptions about a candidate. So it might be, for example, where we make assumptions of those with children or those who want children that maybe they're not committed to the role that we want to recruit them for. Or maybe we might say that if there was an older candidate that applied for the role, that maybe they're not going to be able to fit in because we've got a younger sort of work group, or they might not be able to grasp the use of modern technology. And again, these are just based on stereotypes or things that we assume about the older generation as well, which are often simply not true at all. Now, to tackle unconscious bias, as I say, it can be quite a difficult thing to do, but you can consider a couple of steps. So you could try and keep a paper trail of why certain decisions were made and the grounds for those decisions, which creates that paper trail in case you are, facing a tribunal claim for discrimination, because then you can demonstrate actually it wasn't based on your age that we made this decision. It might be because you don't have the necessary skills or qualifications that perhaps a younger candidate that applied for the role actually did have as well. Another way you could do it is through blind recruitment techniques, where let's say, you've had an allegation of an ethnic minority saying they've not been sort of interviewed for the role because of their name, sounding like a foreign name, then what you could do is just basically blind recruitment technique would involve sort of removing identifiable information from the CV during the initial screening. So the hiring managers don't know anything about this individual other than what's written in the CV. So they don't know perhaps where they live if you remove that, what their name is, their email address, so on and so forth. And another way you could sort of try and tackle unconscious bias is ultimately providing training to staff members, really, to help them recognize their own biases, perhaps, and how this can affect really workplace dynamics and also their own decision making, which they may do without even realizing as well. Now, when we have a situation where perhaps an employee is not quite happy with the way we dealt with something, they might actually raise a formal issue and make a formal complaint, which is typically in the form of an grievance. And that could be about, if we focus on this topic about discrimination and harassment in the workplace, then these types of issues really ought to be dealt with quite carefully. And importantly, it should be dealt with empathetically as well. Because ultimately, if we provide a poor response, it can actually inflame a situation, it can damage trust, and it can also, in some cases, increase legal liability as well. Now, when you have any allegation of discrimination, no matter how small, it is always important to try and treat it quite seriously. So even if someone says, you've not invited me to a work event because I've got a disability, which might seem minor in the grand scheme of things, but it is important that we take it quite seriously because it could be quite serious to that individual as well, or it might be quite important to them. Equally, it's important to try and deal with those issues swiftly, as I mentioned earlier, as well, to try and show that you are taking it quite seriously, because any delay in acting could suggest that you're not taking it seriously at all and you think of it as a minor issue. Now, if you have an employee that does actually require support when they raise some sort of issue, then you could consider measures such as temporary working arrangements, and those things should be given proper consideration as well. Other ways you can try and support an employee perhaps would be through the use of an employee assistance program if you have one of those. Well, it's not mandatory, but it is a good thing to have, whereby an employee may be able to speak to a third party quite comfortably about issues perhaps in the workplace, or maybe even issues within their own sort of personal lives as well. Now, if an employee makes a complaint, then the first thing you'll need to do is consider investigating that complaint if it is a grievance. So it's worth asking the employee, how they want to raise it, go through your grievance process, which is typically what you'll need to do. But sometimes you can ask them, do you want to go through the formal grievance process, or are you happy for us to deal with it quite informally? It is always best if we can to try and deal with them informally where possible. Although, as I say, if the employee wants to take it a step further, then also allow them to do that too. Now, if they do agree with the informal approach, then that typically means just having a sit down discussion with the employee to resolve any issues, whereas a formal approach would typically begin with that investigation I mentioned. So the investigation in the formal process would be really used to obtain all of the fact and all the information relevant to the employee's complaint itself. And this would involve asking the employee questions to clarify the background, as well as speaking to any sort of witnesses, including perhaps the perpetrator or perpetrators, depending on the situation. It would also include steps such as gathering CCTV footage or any other sort of relevant documentation as well. And what you should do is try and keep a record of everything as well. And it goes without saying that confidentiality should, of course, be paramount in these situations. Now, once all of the relevant evidence has been gathered and considered, and once you've spoken to everyone, concerned in the situation, then a decision should be made on the balance of probabilities, and a report should be ideally drawn up with the findings and conclusions, and then it should be shared with the relevant parties, including the alleged victim and the alleged perpetrator or perpetrators. Now, if any complaint is upheld against the perpetrator, then you should take appropriate action on the back of that. And that could range from invoking your disciplinary procedures to mandating perhaps training, policy changes, or working arrangements as well. Both parties should also be given the right of appeal as well, in case they're not happy with it. And that should be, something you deal with equally as carefully as the initial sort of grievance and the initial steps taken. Preventing victimization is another way you can sort of demonstrate you're handling employees. complaints effectively, because employees who raise complaints should be protected from being victimized in any way, so from being treated at any sort of detriment. And that should also be extended to anyone that is perhaps a witness to the alleged situation, and those that participated in the formal grievance process as well. So it's not just the employee that is the alleged victim, it extends to those perhaps who are witnesses as well, depending on the nature of the situation you find yourself in. Now, some common mistakes you may find yourself in is trying to resolve something informally without, doing at least an investigation. So, that's an easy mistake to make. So even with an informal step, try and do some sort of investigation at least. You should also not assume complaints are malicious, just because you feel that, the employee may have raised it in a certain way, or you maybe feel as though they're crying wolf if they've, made similar allegations in the past which were not upheld. You shouldn't automatically assume it's malicious. You should equally treat any complaint as serious as any other complaint as well, and make sure that you still follow the proper process in relation to that. Equally, you shouldn't make any sort of decision based on someone's seniority rather than the evidence. So you shouldn't assume that just because someone junior is making the complaint that against a senior person, that the senior person must be telling the truth. You should make a decision on the balanced probability after speaking to all of the relevant parties involved, and make that decision on the evidence rather than on the basis of their seniority within the workplace. Another sort of common mistake would be failing to get sort of adequate records, which could be the investigation notes, it could be the meetings that you have with the witnesses, or the evidence that you consider, or it could even just be taking too long to investigate an issue, which could undermine the whole process. So it's very important that you document that process. So if you do need to take additional time because maybe the issues are quite complex, it's important to communicate that to to the victim of the alleged offence, but equally document that as well in case you need to rely upon that later on down the line if there is any sort of escalation. And finally, it's also good to have that sort of documentation that I mentioned, just to demonstrate you've acted fairly if it goes any further. Now, avoiding financial and reputational damage from non-compliance is quite important, because failing to take reasonable steps to prevent discrimination in the workplace can have quite significant consequences. And that ranges from, as I mentioned, financial costs to reputational damage as well. Also, employers can actually be held vicariously liable for the action of their employees. And what that essentially means, that is, you can be responsible for any sort of discrimination committed by an individual employee at work, unless you can demonstrate that you, as a business, took all reasonable steps necessary to prevent discrimination. So, to prevent discrimination from occurring and to reduce the risk of vicarious liability, you should consider sort of the steps that I mentioned earlier, such as providing training to staff, creating those policies such as anti-discrimination. You should investigate any allegation of discrimination, and also take disciplinary action against any perpetrators where they are found guilty of discrimination as well. It's also worth noting that simply having a policy isn't enough. You have to actively implement and enforce the measures that are stated within those policies as well. So it's no good just having it in writing. Discrimination claims are something that are becoming more and more common these days in the employment tribunal, largely due to the fact that, employees don't face any cost barriers when it comes to bringing tribunal claims, and the government have recently announced that they don't planning to sort of change that at all. So even if they have a weak claim, some employees try the luck and bring a claim anyway, because sort of defending a claim of this nature can be quite costly, particularly when we sort of think about legal costs. But it's equally important to think about the sort of awards that may be issued to an employee if they bring a successful discrimination claim as well, because often these can be uncapped without a limit on the amount that a tribunal may award for them. So awards are typically for injury to feelings when we have a discrimination case, and that typically consists of things like financial losses, personal injury damages, and aggravated damages if something was handled poorly by the employer. Some recent high-profile cases, in fact, you may have seen in the news, have seen cases exceed £100,000 in compensation to employees. And the legal costs for defending claims of this nature also is quite costly, ranging from £10,000 to £50,000, even if it's a successful defence that you bring as the employer. It's worth noting that ultimately, those costs, that 10 to 50K that I mentioned, is not something that you can typically recover in the employment tribunal from the claimant, even if they bring a successful claim, because it's not the sort of automatic rule perhaps that you may see in most civil claims. It's actually by exception in the employment tribunal. Now, indirect costs that you need to consider as well with any sort of tribunal claim is the management time that has to be spent on investigations of the initial issues, recruitment expenses from increased staff turnover, perhaps, productivity losses, and even potential premium increases as well. But equally, you have to think about reputational sort of damage as well, because almost all matters that end up in the employment tribunal are made public, with the decision being published online. So I can quickly go onto the tribunal decision page, type in an employer's name, and I can find all the judgments that have been issued against that company, which is what a lot of sort of journalists do. And that's how they find out about a lot of these sort of claims as well, and how much has been awarded. With social media now even more prevalent in this day and age as well, claims and even sometimes complaints of discrimination often end up on things like Facebook, Twitter, which is known as X now, Glassdoor, and even on LinkedIn as well. And, perhaps more with the younger generation and demographics, that's increasingly led to boycotting companies that have been found to have acted poorly to complaints of discrimination or have been found guilty of discrimination as well, or these individuals may call for boycotts as well, not only just boycotting themselves. High profile cases I mentioned as well can lead to media coverage as well, which can have serious reputational damage and impact the ability to attract perhaps new clients or even employees as well. And in summary, the sort of cost of discrimination far exceed prevention investment. Proactive commitment ultimately is sort of to equality isn't just legally required. Really diverse and inclusive workplaces usually improve sort of employee engagement, retention, perhaps social standing, and typically create more of a positive workplace culture. So that's all for now in terms of the main points. Before I get on to your questions, then I will just hand over back to my colleague Jay just to go through a couple more points. Thank you.
Thank you, Saeidul. I think that was really great. I think we all learned something here for sure. So this basically concludes the very main part of our webinar. We will answer your questions soon, so just get them popped in the box below. If you missed it earlier, do download our How to Hire and Inspire UK resource. You can just scan the little QR code here, or it'll also be in the resource tab. We do these webinars about twice a month. So you may also be interested in our next webinar. And you can join us on November 4th. It's about UK director compliance and legal obligations in companies' house and ID update. So those are always at 11 o'clock. You can register through the link or on our website. So while you all pop in your questions, I want to take a minute to tell you about the LegalVision membership. We have thousands of clients, about 83% of them are on the membership. Basically, what that means, being a LegalVision member is like having a legal counsel in-house, but at the fraction of the cost. So it gives you unlimited access to hundreds of specialist lawyers. We are a full scope commercial law firm. So the idea is when you work with LegalVision, you would never need to use anyone else for your business. And if you're using us between 4 to 7 times a year, you are breaking even, if not better. So the idea of the membership, it covers things like unlimited documentation, whether that's drafting them, reviewing them, all your consultations for your peace of mind, lots of IP protection, such as your trademark registrations. We have industry-leading turnaround times, and it's all at an affordably monthly cost. So do remember that being part of this webinar gives you access to a free complimentary legal health check with us by just filling in your details in the survey at the end. It'll just be about 30-minute conversation for us to understand your business, and we can give you recommendations from a legal point of view. Of course, give you a tailored solution if that's something that's of interest. So I'm going to hand back to Saeidul in a moment. You'll see a little poll question pop up. Please do answer that. It's just, how are you currently managing your legal needs? So get that filled out, and now I'll hand over to Saeidul to answer all of your questions.
Thank you very much, Jay. So I can see that we have had quite a number of questions come through. So apologies in advance if I don't get through all of the questions that we've got, but please do make use of that complimentary consultation shown on the screen. So if we start off with the first question, then we've had a question about, let's have a look. So we've got a few here. So what constitutes effective training in the eyes of an employment tribunal, and how often should that be refreshed? That's a great question. So ultimately, it really depends, I guess, on the administrative resource that you have as a business, because it's going to be very different depending on whether you're quite a large organization with, hundreds, if not thousands of employees, compared to perhaps, say, a small to medium-sized business, which may have, 1 to 5 employees or less than 50 anyway. So there's no sort of, I guess, one size fits all approach in this situation. But if we go through sort of a general rule of thumb, in my opinion, I would say effective training would be at least, when you have new starters, that you have some sort of introductory training or induction training, whereby you go through some important things. So focusing on, the topic of this webinar on discrimination, you would certainly want to consider having some sort of equality and diversity training going through, similarly to how I've gone through in terms of the different forms of discrimination, do's and don'ts in the workplace. And also equally, if you've got any policies, which I would strongly recommend, going through those as well and what those mean to the business. And equally, if there is any allegations of discrimination, what an employee can do to report that to the business, whether that's through your grievance policy, whether that's through the whistleblowing policy, or perhaps even both, depending on the situation itself as well. You also want to consider really training, I would say, at least annually, or in the back of any sort of incident that takes place in the workplace, just as a general sort of refresher to all staff as well. And I would certainly recommend having a training register as well, which details exactly who attended the training, on what date, get them to sign it, because it's a useful tool to have in case, someone, does act in a discriminatory training manner later on. You can say, well, you attended the training, so you know right from wrong, essentially, when it comes to discrimination. And that could be used to build a case against them in, in certain cases, depending on that situation. So hopefully that answers that question for you there. So I move on to another question that we've got here then is, so with the new government employee bill, can we feel that we could see any exchanges being added to flexible working after 2026? I guess this is kind of linked to the sort of webinar in relation to disabled employees and making sort of adjustments for them. So the Employment Rights Bill has been announced by sort of Labour government, and most of which is going to be taking effect from autumn 2026. And that will have quite a significant sort of impact on employers, generally speaking. But mainly focusing on the question then about flexible working, well, the government's plan really is to try and make work pay, is, that's their slogan. And what they want to do is try and make flexible working basically an automatic right and default position for all members of staff, and only allow employees to refuse a flexible working request if it's reasonable to do so. Now, employees, generally speaking, can refuse flexible working requests if they have one of the statutory grounds to refuse that request. So that could be, for example, the cost of implementing that adjustment. It could be negative impact on work quality or meeting customer demand, so on and so forth. But ultimately, what you'll need to do is consult with the employees, and the bill is going to make sort of the process more defined as well. So really, employers will have an extra layer of obligation to be more clear in the reasons and the rationale for declining requests, and consulting with their employees as well. And in fact, even further than that, if there is an escalation of an issue, an employment tribunal can actually assess whether or not you've taken a decision that is reasonable in their view, based on the circumstances you faced, and whether you actually followed a fair process as well. So hopefully that answers that question there too. We've got another question then about how do you know if the reasonable adjustments made are enough, and how do I decide what is enough for a business to accommodate? So that's again another good question. I guess that sort of links to the effective training question beforehand, on the sense that it really depends on what sort of administrative resources that you have as a business, because it's very different between a large business which maybe can have unlimited funds to accommodate someone with a disability, compared to a smaller business which may have very limited funds, if any. Now, I mentioned earlier, there's different types of discrimination: direct, indirect, so on and so forth. But I mentioned towards the end that there are other types, including making reasonable adjustments. So, generally speaking, if you have someone with a disability, you are under a duty, legally speaking, to make reasonable adjustments for that employee. The key question is, what is reasonable? And as I say, that links back to what your administrative resources are. So if you can afford to do something and put something in place for an employee, then you should go ahead and do so. But if you can't, then it wouldn't be expected for you to do that. But some things that all employers could consider would be perhaps occupational health, where you could make a referral to a third-party specialist that may assist you in identifying maybe suitable accommodation that you could make based on the sort of resource that you have as a business. That could be, certain things like changing someone's start time and finish time, maybe because they've got some sort of disability which impacts on their ability to turn up to work on time. It could be, let's say, a dyslexic employee is supported through some sort of grammar tool like Grammarly, for example, as well. So sort of small things that maybe all businesses could consider implemented. Equally, you could just have a discussion with the employee to find out, what works for them and what is enough for them as well. Perhaps on the back of that occupational health referral, or if you can't afford to do that, just by general discussion with them to see what you can do to assist them in the workplace. But at the end of the day, if you're a small business and you've got an employee, let's say, that has a wheelchair and you've got a ramp and stuff in place, but they might find it more beneficial to have an elevator installed. If you've got the money to do that, great, you should consider doing that. But if you don't, you're not going to be expected to do that, because that may not be reasonable for your particular sort of workplace and the resource that you have. So hopefully that answers that question there for yourself too. We'll go through perhaps one more question before I just hand back to my colleague. So let's have a look. What else have we got? So we've got a question here then, is what is the company's obligation to report harassment claims to local authorities or police? And how should global companies manage harassment claims involving different country and their legal sort of jurisdictions? Well, first, I mean, I can't really speak about other jurisdictions. I can only sort of focus on England and Wales, and to a certain degree, I guess, Scotland as well, which is generally the same. But in most places, employee and in most jurisdictions, a company's going to have really a duty of care to try and protect their employees and sort of protect them from any sort of discrimination in the workplace, and may face liability if they fail to act appropriately. But companies generally aren't legally required to sort of report sort of workplace harassment to the police. And I would say the only exception to that would be if the conduct committed by, another employee or a third party is quite a serious offence. So that could be, for example, sexual assault. It could be physical violence, for example, or it could even be something like stalking, for instance. So those are all quite serious offences where I would certainly recommend involving the sort of relevant authorities there. Equally, if the sort of victim is a young person, so someone under the age perhaps 18 and younger, that's when you might want to sort of consider reporting it to the relevant authorities, maybe even to their parents as well, so they're sort of fully across that too. And then finally, perhaps if there's an ongoing threat to the safety of that person as well. But at the end of the day, you want to try and protect that employee as far as you can, because you have that general obligation to protect that employee's health and safety so far as is reasonably practicable. So if there is that ongoing threat, see what measures you can put in place to protect them, and that could be as simple as reporting it to the local authorities. So I hope that answers your question too. Apologies, there are a few more questions I'm not going to be able to get to now. So what I'll do is I'll just hand back to my colleague, Jay. But as I say, if I've not managed to get to your question, please do make use of that complimentary consultation you get for attending today's webinar. Thank you very much.
Amazing. Thank you so much, Saeidul. That's been great. And so, yeah, this is pretty much all we have time for today. But thank you to everyone who's attended. While these webinars are free and we try to do them as frequently as we can, we do really value your feedback. So please take 30 seconds to fill out that survey. That way we can keep giving you guys this information. We want you to make the most of it. If we didn't answer any questions, also pop your details in that. You can, contact us on our website. The phone number you had on the screen earlier, or just in the survey, is absolutely fine. Or if you want to learn more about how the membership can support you, your legal counsel, no matter where you are in your business stage, we can have that conversation and go from there. But thank you so much for joining us today, and we'll see you next time.